Hello, my name is Brendan Snowden. I'm the co-chair of the corporate department. I'm giving a presentation about the Corporate Transparency Act today with Betsy, Falkoff. So we're going to go over the Corporate Transparency Act today. We're going to kind of get through the basic rules and then to as many examples. There is no real world yet, but hypotheticals about how to apply the rules to various situations that may pop up. We'll get through as many examples as time permits. The purpose of the Corporate Transparency Act, which was passed in January 2021, so now we're almost 3 years in and we're just now starting to implement it, was to combat money laundering and is to increase financial transparency and protect U.S. national security and financial systems from illegal use by providing the Financial Crimes Enforcement Network, which is FinCEN, with beneficial ownership of pretty much almost all companies that will be formed or operating in the United States. This is a jump off of what are common rules in most of Europe. European rules are generally a little stricter than what's going to be in the CTA. Secondly, this is also kind of similar to what a lot of companies also have to give banks today. So again, beneficial ownership information. So the type of information that's being disclosed is not necessarily new. What is new is the scope. The key takeaways to come out of this is, one, this will impact virtually everyone and virtually every company that will be formed or operating in the United States. Even if you never form another company, it will still impact you because you will be investing in companies who will have to report the beneficial ownership, of which you may be defined as a beneficial owner, or you or your clients. The other takeaway I want to have is, despite that statement, this isn't as bad as it looks. And it should be fairly straightforward. So the basic rules are bifurcated into two. For any companies that are going to be formed, they're starting in 2024 and onwards, you have 30 days to report your beneficial ownership to FinCEN. You'll see the last bullet point there. There was a proposed regulation to extend that 30-day period to 90 days for entities formed in 2024, because basically everybody's panicking. That was a proposed rule as of when we made this presentation final. It's now a final rule, so now you have 90 days to report for 2024. Starting in 2025 and onward, you're going to have 30 days to report your ownership. 30 days from the date of formation. But technically, it's from the date that you know that the company has been formed. As probably everybody's seen, there's usually a few days lag between the date you get as kind of the effective formation date and when it shows up on the Secretary of State website. But in essence, it's 30 days. The impact of the Corporate Transparency Act is not just for future companies, it's for all companies that exist today. So that's whether the company is formed in 1899, 2009, December 31st, 2023. All those companies are going to have to start reporting their beneficial ownership beginning January 1st, 2025. It doesn't end there, so it's not just an initial report. The reporting companies will also have to report any changes to beneficial ownership within 30 days of the effective date of that change. So who has to file? Again, basically any company that is formed by filing something with the Secretary of State or similar government office. So that's going to be corporations, that's going to be limited liability companies, that's going to be limited partnerships. It's not necessarily going to be kind of just general partnerships, joint ventures, kind of things that you're not actually physically filling out a form and submitting it to a state, and then there's a public record of that entity being formed. The obligation to file is on the company. It's not on the beneficial owners. So furthermore, it does not distinguish by purpose or complexity. This is going to apply to the entity that you form, and we'll have an example of this, but the entity that's formed to own a house, just as much as it's going to be formed to own an operating factory. There are a number of exemptions. Most of the exemptions here kind of have one common denominator in that they are already subject to oversight from some kind of regulatory entity. So Exchange Act reporters, so public companies, banks, insurance agents, investment companies, investment advisors, tax-exempt entities, all those will be exempt. One other key exemption is large operating companies. So that is defined as an entity that has 20 or more U.S. full-time employees. It has a physical office in the United States, and it has at least $5 million in gross receipts as reported, or revenue as reported in the most recent tax return. Those exemptions should take care of, kind of going back to the theme, should take care of a lot of the more complicated structures, so you're not having to worry about kind of what I just issued a whole bunch of stock options to my employees. Do I have to count them? What happens with them? Because, again, the idea would be that most of those companies are going to be exempt, but under the large operating company exemption, at least at some point. So who is a beneficial owner? Beneficial ownerships, there's not just ownership, which is strange, but that's how they defined it. There's two prongs. One, you can be a beneficial owner by having substantial control of the entity. The other is you can be a beneficial owner by just, well, being the owner. The ownership interest test is anyone who owns 25% or more of the equity of the company. We'll get into kind of what that means. Obviously, there may not be anybody who owns more than 25% of the company. So FinCEN wants at least somebody to report, so there's also a substantial control component. If you're not a beneficial owner because of the ownership interest, you still may be a beneficial owner because of the substantial control. So you're going to always have to report at least one person in the filings. So substantial control are individuals who control indirectly or directly, basically the operations of the business. There's a laundry list of people that are by definition will have substantial control. That's going to be any senior officers. The president, the CFO, general counsel, CEO, COO are all explicitly identified as people that will per se have substantial control. Also, people who can appoint the majority of the board or otherwise appoint officers. There's another prong where if you have influence over the direction of the company, you will also be considered to have substantial control. And then there's a catch-all. The theme through all these is that other than the kind of officer test and the power of appointment test, the rules are trying to combat money laundering. So they are intentionally overbroad and ambiguous in definition because they want you to over-report. They don't want you to structure around reporting. The second way in which you become a beneficial owner is ownership interests. Again, anybody who directly or indirectly owns at least 25% of the ownership interest of the company. Ownership interest of a company is, again, broadly defined. That includes stock, membership interests, so forth. It will also include options, puts, calls, derivatives, those sort of things. It'll include convertible instruments. It will likely include safe notes, if anybody's kind of been involved with those. Again, the idea is to be overbroad and to capture things that, just because they're not named equity, if they have equity-like rights to them, they are supposed to be considered in this prong. In calculating whether you're reaching the 25% or more threshold, stock options and similar and convertible notes, those things are supposed to be calculated on an as-converted basis. Two other kind of special rules. For LLCs, you're looking at it on a global level. So capital interest, profits interest, even if you have different kind of subsets of membership interest, those are all kind of folded into one. So if you have somebody with a 30% profits interests and the rest is capital interest, both of those owners are going to have to report. On the corporation side, they look at it more of a bifurcated kind of scenario. You can hit the 25% or more if you have 25% or more of either the voting control or the economics. So if you have a non-voting slug and a voting slug, those will be kind of looked at independently. Who isn't in a beneficial ownership? There's a few kind of specific exceptions, minor children, inheritance. We'll talk about kind of the creditors later, but just kind of people who aren't really beneficial owners. Again, they're kind of acting through somebody else, and those somebody else's are the ones that are actually are going to be the beneficial owners.
So when a trust holds an interest in an entity that's subject to the CTA, there can be multiple individuals who have a role or interest in the trust that can be deemed a beneficial owner. As Brendan discussed earlier, to determine whether an individual is a beneficial owner, there are two tests. The first is the ownership or control test, and the second test is the substantial control test. So in the trust context, the final rules provide the examples that you see listed here of individuals who could be deemed to be beneficial owners through ownership or control of 25% or more of an ownership interest in the reporting company. So the first is trustees or any other individuals, both fiduciaries or non-fiduciaries, with a right to dispose of trust assets. Next, we have beneficiaries, who are either the sole permissible recipients of income and principal from the trust or have the right to demand a distribution or withdrawal of substantially all of the trust assets. This includes a beneficiary who has a present power of appointment. It's unclear as to whether this also applies to beneficiaries who have a testamentary power of appointment because future interests are excluded under the rules. This example seems to imply that if there's more than one current beneficiary of a trust, the other beneficiaries, they're not deemed to be beneficial owners under the ownership and control test. It's unclear sort of at this point whether or not that's true. So we'll wait to see if more rules or analysis are put out. And then lastly, we have a grantor who has the right to revoke or otherwise withdraw the assets of the trust, which is pretty straightforward. The final rules also provide for the aggregation of an individual's ownership interest, which means that if, for example, a trust holds less than a 25% ownership interest in a reporting company, but a trustee owns an individual interest in a reporting company, and when taken together, the trustee's ownership interest and the trust ownership interest exceed 25%, then that trustee would be deemed to be a beneficial owner. Second, the rules provide an outline of examples of circumstances in which a trustee or other individual may exercise substantial control, which is really a facts and circumstances analysis. Brendan spoke earlier about the examples in which an individual can be deemed to have substantial control. This includes a number of different scenarios. An individual who holds veto power, owns or controls a majority of the voting power or voting rights of a reporting company, is on the board, or is a senior officer, president, CEO, CFO, general counsel, has the power to remove and replace a senior officer of the company, and directs, determines, or has substantial influence over important decisions of the reporting company. And if that person does have that substantial control, then they would be deemed to be a beneficial owner, and that person can be both a fiduciary or a non-fiduciary.
In addition to beneficial ownership, at least for companies that are formed after 2024, you have to also report basically the people who actually did the filing, and those are called company applicants. There's going to be at least one and a maximum of two company applicants that have to be reported. One is the person who actually does the filing. That could be the client, that could be an attorney, that could be a CPA, that could be a service agent, whoever actually goes to the Secretary of State or similar office and says, here's the filing. In addition, they also want to report the person who is responsible for preparing or kind of directing that filing. Again, that's probably going to be a professional of some sort, a CPA, a financial advisor, attorney, whomever, not necessarily the client who's going to be captured under being a beneficial ownership. Unlike beneficial owners, you don't have to update the company applicant records. So in the initial filing, you'll have to include them only for companies that are formed after 2024. The initial regulations kind of indicated that we were going to have to find the company applicant from the company that I was thinking of that was formed in 1899. We don't have to do that anymore. It's just companies kind of going forward. What has to be reported? So the reporting company has to report its basic information, its legal name, any DBAs, its street address. So this address may not match what's in what you give the Secretary of State. A lot of people use kind of advisors' addresses or COs or PO boxes where they can get away with it. Can't do that here. It needs to be a physical, actual address. Jurisdiction of formation, and then the EIN or tax identification number for the company. For each beneficial owner, full legal name, date of birth, their home address, again, shouldn't be a care of or some other address. It needs to be the actual address that the beneficial owner uses, usually what's going to be in their ID or their tax return. Incidentally, they also need a copy of driver's license, passport, or what have you. So the company is going to be responsible for identifying its beneficial owners, going into tracking those beneficial owners down, and getting a copy of their passport or ID. don't think I mentioned it up front, but again, this is all private information. It's going to sit in an office or a secure kind of facility or whatever at FinCEN. We'll get into kind of when it can be disclosed, but this is not something that's going to get kind of published out in the world, similar to what Secretary of State filings do. That doesn't mean that states won't jump off this and start requiring some of that information to be public. New York, at least the legislator passed a law in the spring that would require just LLCs to report the names of their beneficial owners as calculated pursuant to the CTA rules in a publicly available database in New York. The governor's been sitting on that for 6 months. Still hasn't been passed, so no one really knows what's happening. I know in California, there's also talk about kind of making some of this information public. So again, while the stuff that is going through to the CTA is not public, that doesn't mean that states aren't going to take it and kind of run with it. We talked about when filings are due, basically three groups. Anything formed before 2024, you'll have until 2025 to form. Anything formed in 2024, 90 days from the formation time. And then anything formed in 2025 and after, you'll have 30 days to form. Any changes in reporting in who your beneficial owners are or in the information that your beneficial owners provided to you, you will have to report those changes within 30 days. So if someone dies who's a beneficial owner and their interest has been transferred, the company will be responsible for finding that out and then reporting it. It's not an awareness test. It's an actual kind of when the event happened. So what we would expect to do from a practice standpoint is pretty much every operating agreement that we're now putting together will have a provision in there that says, hey, you owners are responsible for providing me this information when and as asked. Penalties for failure to comply are pretty stiff. It's fines up to $500 a day, criminal penalties of up to $10,000 and 2 years in prison. Whether or not, practically speaking, somebody's going to go to prison who's not a money launderer, I don't know. But the penalties are stiff enough, and the way FinCEN has been approaching it is enough to say that they are taking it seriously, and they do expect compliance. The person who is the company in this sense, it's probably the person who would be the same person who would be having to report as substantial control, so kind of the main person at the company. It's also going to be somebody who willfully refuses to provide their information. So if the company can't report its beneficial ownership because one of its members just refuses to provide it, that person could also be on the hook here. Talked about who can access. Again, it's private. The only people who can access information are certain entities needed for law enforcement reasons. There are proposed rules for kind of how that's going to work. They still have not been passed yet. Secondly, this is also supposed to eventually kind of replace or at least supplement customer due diligence rules at banks. So now the banks, rather than having to give you a laundry list of KYC, although I expect they'll still give everybody a laundry list of KYC, it'll at least limit that to where the banks can go directly to FinCEN to get that information rather than having to go to the individual companies. So this is one of those cases where if this works out right, this is actually going to make things a little easier for companies kind of going forward. Okay, so a few examples, just kind of put this in practice. So the first one is Homer has an LLC that he has to hold a vacation home in Shelbyville. He's the only owner. There's no business purpose to this whatsoever. It's just to hide the people, so people in Springfield doesn't know he has a house there. He has to report. Doesn't matter why he did it, where he did it, he has to report. So he's going to have to report his beneficial ownership, whether it's under a substantial control test or the ownership test he's reporting. A couple variations kind of make it a little more complicated than that, but
Yeah, I mean, the first example of revocable trust, pretty straightforward. If we're assuming Homer's revocable trust owns 100% of the LLC, Homer as grantor would be a beneficial owner, Marge as trustee would be a beneficial owner. Marge and the children as equity holders, 5 owners of 20% each, they don't qualify under the ownership or control test because they don't have 25% or more of an ownership interest in the company. We're assuming that they do not exercise substantial control in this example.
So the last variation is, let's say you split it up as you commonly do, is Homer still wants to run the LLC, but he wants to give all the equity to his kids. So you create two classes of interest. You have a voting class and a non-voting class. The kids get all the non-voting, 33% each. All three of them are going to have to report because they own more than 25% of the ownership interest of the LLC, calculated on an aggregated basis. Homer, you would think maybe wouldn't have to report because he's only 1% owner, but that's 1% is in voting. So going back to the substantial control test, he has the ability to basically run the company. Doesn't matter if he's appointing somebody else as a manager to run it. He has the ability to remove and replace the manager. He has the ability to direct the operations of the company, so he's still going to report as under the substantial control block. Example number two, let's say Homer forms another LLC, transfers into his LLC his shares in Landley Monorail that he earned as equity comp for the LLC. He gives the interest in the LLC to three irrevocable trusts for the benefit of his three children, and Marge is the trustee.
So in this example, the beneficial owners would include Homer as the investment advisor, Ned as the distribution advisor. In the operating agreement context, right, Brendan, that would be the same investment?
Yeah.
Yeah. And then the trustee of each trust would also be a beneficial owner under the ownership control test because each own over 25% ownership interest in the company. And then the beneficiary of each trust would be a beneficial owner, assuming that each child is the sole current beneficiary of their respective trust.
And so if the trustee changes,
Triggers reporting.
again,
requirement.
it triggers a reporting requirement because somebody's kind of sliding in as the new kind of representative of the trust.
Right.
A few variations. So let's say Homer's LLC owns 35% of Monorail Inc. So Monorail Inc.'s, let's assume that it's not an exempt company under the 5 million and 30 or 20 employee rule. It's going to go to Homer, or it's going to go to his LLC and say, who are your beneficial owners? Homer's going to have to report its ultimate beneficial owners to Landley Monorail for Landley Monorail to include them in the report. There is something, and I didn't put it in here just for time reasons from a slide standpoint, but the government does allow individuals and companies to go out and get what's called kind of a FinCEN identifier. And basically what that means is you're providing all your beneficial ownership information to FinCEN directly as an individual. And anytime a company comes to you that you happen to be a beneficial owner in, you can give that number directly to the company instead of all your personal information. So in this case, Homer applies for a FinCEN identifier. He gets it. Landley Monorail comes asking him for his information. He just gives him the identifier. The company doesn't have to do anything else. The downside of that is now Homer is responsible, at least until he dies, to continually update his information with FinCEN. FinCEN recognizes that this seems a little kind of heavy and will kind of limit the use of people for FinCEN identifiers. They're kind of looking at a solution and kind of see kind of where it goes.
The three children will own equal interest in the LLC. Bart pledges his interest to his bookie. Lisa gives her interest to charity. Maggie puts her interest in a dynasty trust for her descendants. Lisa's interest, charities are exempt from reporting, but the LLC does need to report that the charity owns an interest. All of these transfers would trigger reporting requirements, obviously, like we've reviewed. And then for Maggie's Dynasty Trust, the questions to ask are, who are the beneficiaries? How many are there? Do any of the beneficiaries have the right to withdraw substantially all of the trust assets? Do they have a present power of appointment? And then who are the trustees or other fiduciary or non-fiduciaries who have an interest in the trust with a right to dispose of the trust assets? And that's how you would determine who would be the beneficial owners.